There are some areas where you do need to tread particularly carefully, where there are in effect statutory limitations over and above the malicious communications sort of issue. For example, if we are prosecuting a sex case, anything that you tweet that might lead to the identification of the victim would probably infringe a specific section of the Sexual Offences Amendment Act. I recently prosecuted under that Act, not a social media case, but a newspaper who had published the name of a victim of a indecent assault. And the editor himself was charged with the offence. He was subsequently acquitted, but he was extremely worried because he had occasion to travel to the United States a lot, and a conviction under the Sexual Offences Amendment Act would have effectively prevented him from going back into the United States, because they wouldn't quibble about whether it was a sex offence as we might know it generally, and something which was a publication offence in effect. Also, if you start tweeting credible threats, threatening behaviour, you might be caught by that legislation. For example, we prosecuted a number of people who were tweeting at the time of the disorders here in Manchester and around the country in the summer of 2011. A number of individuals were prosecuted successfully, meet you at Bang & Olufsen, we're kicking the window in at 4 o'clock and helping ourselves to a hi-fi. That sort of communication, which was judged in the end to be credible, and therefore convictions followed. But as I say, we're not trying to be heavy-handed when it comes to prosecuting people who are just expressing views, even strong views, because we realise that we have to balance our approach with the right to free speech.
Thank you. Helen, can you give us a Scottish perspective?
There are actually 3 seats at the front here. I can see a lot of people standing up. There are 3 spare seats, so if people want to come down and claim those 3 spare seats, I'm not going to laugh at you or think anything is funny. Very briefly, to do what Ian did in a short space, Scotland is a separate jurisdiction. It has different law. The pith and substance of its difference is about 50% of Scots law is derived from Roman law, which means it's closer to the law in France or Germany than the law in England. This has a particular effect in the law of property, which is completely different, the law of family, which is completely different, and criminal law, which is substantially different. So you'll need to get used to some language first. A sheriff in Scotland is not someone who wears a big shiny badge, that's the judge. The equivalent of the DPP or CPS in Scotland is the Crown Office and Procurator Fiscal Service. It's a lovely Roman name, isn't it? And we call it the Fiscal for short. And there are 2 substantial procedural differences with the power of the Fiscal compared to that of the CPS. The police can never bring a charge. In Scotland, there is no such thing as a police prosecutor. That is always in the hands of the Fiscal. And trial by jury is not at the election of the accused. If a trial is going to be heard by a jury in Scotland, that decision is in the hands of the Fiscal. Scottish juries, there are 15 of them rather than 12. The verdicts are by majority, and we have 3 verdicts: guilty, not guilty, and not proven, which goes back to ancient Rome. As Ian was talking about, when you're talking about defamation, you're talking about the civil law. In Scotland, it's a delict. In England, it's a tort. Someone privately offended in some way, shape or form needs to bring the action. It can't be done by the government. Now, the law of defamation in Scotland covers both libel and slander in England. We use just the one word to cover both concepts. There are once again, some fairly large differences between the law of defamation in Scotland and the law of defamation in England. Without going into an enormous amount of detail and trying to explain the whole delict of defamation in Scots law, I'm going to hope that the audience who's come here has a rough idea of the way defamation works in England. So I'm going to pick out the 2 most crucial differences. The first is that there is a defence in Scots law that also goes back to ancient Rome known as inrixa, which means heated argument in Latin, which means if you call someone a lot of very rude names and say rotten things about them, and it's in the middle of a great big public spat outside the pub, then you can't be called for defamation. It just won't happen, because it's just inrixa. And there is a degree of protection. This concept of inrixa extends to online argument, and that's kind of important because there's this wonderful concept known as Scottish banter. And basically, if Scottish people couldn't do Scottish banter, it would be awkward. So that very traditional idea in Scotland that you need to be able to have a wee go sometimes and get away
I think we
with it.
heard that with Keir last night.
And get away with it. Otherwise you would basically be stuffing a sock in the mouth of pretty much everybody in Scotland, particularly after a game of football. And as an extension of the concept of inrixa, motive is irrelevant in the Scots law of defamation, which means the opinion that you hold, the nasty thing you say about someone, need not be honestly held in order to enliven the defence of fair comment. You can say something that you don't think is true, just to take the piss. Okay? And so you don't, in England it needs to be honestly held in order to enliven the defence of fair comment. In Scotland you don't have to do that. So you can troll, basically. However, all the other things are the same, including the fact that the burden, the onus of proof, is placed on the defender. Oh yes, I need to give you some language. Plaintiff or complainant is pursuer, and defendant is defender in Scotland. So it's the pursuer and the defender. So yeah, think of Roadrunner, and you'll get the idea. So motive doesn't matter, and there's a bit more flexibility, and always has been a bit more flexibility in Scotland that gives you more speech rights. However, those speech rights are cut into by Westminster. So all of the hate speech legislation and all of the racial discrimination legislation, all of that applies to Scotland, but it applies to Scotland not because those laws were enacted by the Scottish Parliament, but because those powers are reserved to Westminster. This is something over which people in Scotland do not have control. So, apart from the decision, say, by the fiscal to not prosecute, it does seem that in Scotland prosecutions are less commonly brought in these kinds of cases, but they are more commonly brought in another kind of case when I get onto the criminal stuff, so I'll deal with that later. We still have the English law in certain areas over the top of the Scots law, and sometimes the conception behind the conceptualising of that English law is quite different because it's coming from a different legal tradition. Now, when I come to the criminal matter, this is completely different. No Malicious Communication Act in Scotland or anything like that, that doesn't exist. Traditionally, when it comes to criminal matters, the online bad behaviour, saying something naughty, is dealt with by a very traditional Scottish crime known as breach of the peace. Now, there used to be a running joke that breach of the peace was anything that a member of the polis didn't like. And if you did it in public and you frightened the lieges, which is this lovely old Scots word for members of the public, then you could be up in front of the sheriff on a charge of breach of the peace. However, what happened with breach of the peace is it became so compendious over time, and I'm going to read a couple of sentences out of the leading Scots criminal law textbook. The breadth of this offence is notorious, and an enormous range of conduct has been held to constitute a breach of the peace, or at least capable in law of amounting to a breach of the peace. Although the offence has been reviewed by the High Court, it is useful by way of background to recall the range of conduct. For example, playing football in the street, playing marbles in the street, peeping into houses at night, secretly observing women using a sunbed, shouting political slogans in support, inter alia, of the IRA outside a football ground, causing offence by selling National Front newspapers outside a football ground. My understanding is that the ladies and gentlemen from the BNP were actually arrested for their own protection. They were insisting in doing it outside Celtic Park. Cross-dressing in Perth.
Is that okay in Aberdeen then?
Well, there'd have to be a case brought in Aberdeen. You never know with these Aberdonians. You might need to talk to Keir. Keir's an Aberdonian. Distributing pamphlets seeking support for pupil power and sexual freedom to young girls to the annoyance of their parents. Curb crawling by males seeking the services of prostitutes. Threatening to commit suicide in a public place. Begging in an aggressive manner. Sitting on a felled tree as a protest at its destruction and obstructing its being cut up. Loitering in and about a liquor store in a suspicious manner. That belongs in Taggart, it really does. Injecting oneself in a locked toilet cubicle. Alarming a third party by glue sniffing, and I think this is absolutely the last one, even though I have another 30 and they're all different. Ordering an Orange Order band to play as it passed a Catholic church as the congregation were going into Mass. And my understanding is that the song they were going to play, and I'm going to inflict my terrible singing voice on you for one line of it, was we are the Billy Boys, hooray, hooray, we are the Billy Boys, and it goes on to sort of talk about wading in Fenian blood. So it's a little bit awkward if you are going past a Catholic church. Many others. As you can see, this just became enormous. And it meant that you didn't have a valid mens rea or actus reus. It was basically something that alarmed the lieges, and the police investigated and the fiscal decided to prosecute. It was also being used to fill up gaps in the law, to deal with particular issues, particularly online football forums where people were planning violent attacks, almost always in connection with Celtic and Rangers, collectively known in Scotland as the Old Firm. So, two things happened. First, a breach of the peace case, the tree felling one, the tree protester, went all the way to Strasbourg. And Strasbourg came back to Scotland and said, dear fiscal, this doesn't mean anything anymore, please define. So breach of the peace was narrowed. And the first thing that was done was a good thing. It was narrowed, and a piece of legislation, Section 38(1) of the Criminal Justice and Licensing Act 2010, was passed to make sure that all the private offences that were brought under breach of the peace historically were dealt with under a separate piece of legislation. However, that still wasn't enough for a lot of people. And this culminated after a couple of really unpleasant incidences where the manager of Celtic was sent a viable explosive device, and a footballer was sent bullets from Northern Ireland. It's always associated with football and sectarianism in Scotland, far more than any of the other issues. A particular piece of legislation passed was known as the Offensive Behaviour at Football and Threatening Communications Act 2012. Now, unfortunately, that act was only put out to consultation, the bill was only put out to consultation for 6 weeks. It's extremely badly drafted. It's very difficult to work out what it means. If you are, my friends who work in the criminal law, because I'm a commercial lawyer, tell me that it is absolutely awful to try to bring prosecutions under because you just don't know what you're doing. It's very difficult to come up with adequate defences, both in the football part and the threatening communications part, because it's just not clear what the legislation means. Now, we all thought that this was just a sort of private thing that Scottish lawyers complained amongst themselves about terrible drafting because the bill was pushed through the Parliament too quickly. However, we now have the support of Scotland's favourite sheriff, Sheriff Davidson in Dundee, who just threw out a case, and in the process of throwing out the case, described the legislation as mince, which I think is quite funny, and that was on the 11th of April. And he made the comment, somehow the word mince comes to mind. But he also made the point that this legislation, which is attacking the problems that are around football, online forums around football, is actually getting at it at the wrong end of the stick. And for an audience of sceptics, and I think quite a few humanists here, sheriffs have quite a lot of freedom in Scots law to sort of sound off about what they think the actual problem is. He made the remark that the problem of sectarianism in Scotland was not going to be addressed by legislation that shut people up on the internet or stopped them arguing about which football team they supported, and he actually came out in a courtroom and advocated the abolition of denominational schools in Scotland. He said that was the root of the problem, and it's caused quite a lot of controversy. Many people in Scotland go to denominational schools. It wasn't my experience because my first degree was in England, it was at Oxford, but many of my Scottish friends have had the experience at interviews for law firms of being asked which school they went to, and it is a proxy for saying, what religion are you? So it's still a problem. It's not gone away. It's a scourge in Scottish society, but instead you're getting lots of young people who say silly things on the internet falling under the aegis of this legislation rather than actually dealing with the root cause of the problem, which is hundreds of years old and has roots in all sorts of very complex aspects of Scottish history.
Talking of which, can I chip in?
Yes?
Crap. Robin Hood Airport is closed. You've got a week and a bit to get your shit together, otherwise I'm blowing the airport sky high. Now, that's what I hope is the kind of thing that we're going to be discussing with Ian and Simon. That was a prosecution under the 2003 Communications Act. Ian, what did he do wrong initially?
Well, I think it's a credible threat. I think that was probably the reaction of the prosecutor looking at that, that it does offend at least the wording of the Malicious Communications Act, where if you are sending what can be deemed to be a credible threat to cause damage, that is potentially prosecutable.
Simon, I think you were one of the prominent supporters of Paul Chambers. What's your view from a non-legal perspective?
Yeah, I mean, I was there on the when the final judgment was read out at the appeal. It was a great moment to be there. But I suppose it kind of it'd be interesting to know from me. And I think the question is it a credible threat? Is it not a credible threat? And at the end of the day, the judge decided it wasn't a credible threat. And I think the police or the security at the airport initially seemed to dismiss the case. So, can you kind of get inside the heads of the people that took the decision?
I know it's difficult. Background to that case, but if it was passed for me for review, obviously I would want to know just how credible this was. Was it just? I mean, there used to be a phrase in English law. Let me be careful how I say this. It was classed as a mere puff, which was a kind of. It was really related to sort of grossly exaggerated claims in relation to products. A very famous case way back in I think almost Victorian times. You're entitled to sort of make claims that people wouldn't take very seriously. I think there's a parallel between that and looking at whether a threat would be credible. So, it's difficult for me to comment on a case that we did prosecute because obviously I'm subject to corporate consistency. But that's the kind of approach. If it was passed to me, just what? I mean, is it just a sounding off because someone has got a flight delay, etc., and therefore it's a bit of a reaction that we turn a blind eye to, or is it really a credible threat? Now, obviously, that would then draw us into fairly lengthy discussions with the investigating authorities, the police, or the airport authority, security service, whoever it was that was dealing with it. And one hopes that there was something. That would substantiate that to trigger, yes, this is credible. But I think that case probably, was a landmark case for us and one which we will take on board and learn lessons from as a prosecuting authority, no doubt.
Well, I think in fact it was that case that led to the consultation, the new guidance. They really are worth having a look at. For example, the initial assessment that somebody like Ian would go through, there's 4 headings that they look at. The first one is it a credible threat, as Ian says. So they consider whether there are communications which may constitute credible threats of violence to the person or damage to property. There's another section, communications which specifically target an individual or individuals and which may constitute harassment. So, for example, if somebody's going through a campaign on Twitter to constantly, really have a go at somebody on Twitter all the time, that's potentially harassment. It could be charged under the Protection from Harassment Act for them. Thirdly, there's communications which may amount to a breach of a court order. Now, Ian's already mentioned the rape case. You may remember, I think last year, there was the case of Ched Evans, the footballer, who was on trial for rape. I think it was a Welsh case, in fact. And there were some people who didn't like the verdict because he was a popular footballer. And they criticised on Twitter and had a right go at the complainant. and named her. Criminal offence, and in my view, quite rightly prosecuted. So that's that category we'd look at. The one that perhaps is going to be of interest to sceptics is where we fall into free speech areas. And the fourth category here, media communications, which don't fall into the previous three, but which may be considered grossly offensive, indecent, obscene, or false. Now, there's a caveat to that particular criteria, because the DPP, I think in fairness, accepts that there are real free speech issues here, and the guidelines specifically tell prosecutors to stand back, and there's a really high threshold for any prosecution where there may well be free speech issues. So what I'm going to ask Ian now, and I did give him a bit of warning about this, so it's perhaps not too unfair. Can you tell us what the difference is between something that is offensive and therefore legal, or something that is grossly offensive and therefore potentially criminal?
Okay, yeah, difficult question. And being a lawyer, I'm going to fall back on precedent in a moment. But our guidance does, and the phraseology I think is quite telling. We recognise what's called the potential for a chilling effect on free speech. So that's quite a bold kind of remark, I think, from the director and his right-hand lady, who is Alison Levitt QC, who's the principal legal assistant to the director, and who has now to approve any prosecutions that we launch in this interim period under this legislation. What is grossly offensive? Well, can I quote Lord Bingham, one of our most eminent, now retired judges. He had to look at this in the context of a case in 2006, a case of Collins, and he said there can be no yardstick of gross offensiveness otherwise than by the application of reasonably enlightened, but not perfectionist, contemporary standards to the particular message sent in its particular context. And I think context is going to be particularly crucial. But as Jeff has said, we're operating a fairly high threshold at the moment, and I can tell you that since we've had these interim guidelines published, I haven't sent one to the director for consideration.
Can I just...
That's how we stand at the moment.
If I can just chip in, because there have been a couple of recent cases, and I don't think they're local, so Ian's not responsible for them. Reading, Sean Duffy, I think last year, he was prosecuted under the Malicious Communications Act for posting images on Facebook and YouTube which mocked the deaths of 4 children, including a 15-year-old girl who had committed suicide. Now, there's no doubt that he was making offensive comments, but he was prosecuted because a prosecutor obviously took the view that what he said and posted on Facebook was grossly offensive. And the judge agreed, and he went to jail for 18 weeks in September 2011, so that would have predated the guidelines. Would that kind of prosecution still pass the current guidelines?
Personally, I would regard that as grossly offensive, yes.
Yeah. Okay.
Just on the Robin Hood Airport one,
Yeah.
making rude comments about Edinburgh Airport being shut and threatening to blow it up wouldn't pass go in Scotland, wouldn't get prosecuted.
Yeah.
Making rude comments about Ibrox and threatening to blow it up would. So the context there is provided by the legislation, which is to deal with the fact that people are not sort of violent about airports in Scotland, and if they are, Scottish people beat them up. However, people have been notoriously violent about football over many, many years, and you can go back historically and find that people have killed each other over football. So context is king.
Can I just ask though, I mean, I can recall there was an attack on Glasgow Airport,
That's what I'm
wasn't there?
saying. Scottish people beat...
I didn't either, but it's fun.
Scottish people, well, yes, Scottish people, you set yourself on fire and say you're going to blow up Glasgow Airport, and the response of
yes,
Scottish
I remember
people
the
is
guy,
basically
yes.
to, yes, yes,
I remember now. Yeah, he's a national hero, wasn't he?
yes,
Yeah.
but it's just so good. We come to Glasgow, we set about it.
So, Ian, can I ask, as far as the guidelines are concerned, what sort of leeway do you give somebody who, you know, might be under 18, or, you know, tweets when they're drunk and wakes up the next morning and thinks, I really shouldn't have said that?
Yeah, we would take all that into account, age, and you know the speed with which someone perhaps puts an apology out or retracts the statement. I think they will be very relevant factors in looking at whether the public interest really requires a prosecution.
And the teenager who tweets something to their 50 followers, but somehow gets retweeted and retweeted. What responsibility do retweeters have in all of this?
Good question.
I haven't come across it, so this is kind of off. I would think if you're retweeting something, that you're effectively adopting it, aren't you? I suppose. So you're beginning to, you know, flirt with danger. I can leave it as vague as that.
Certainly in the civil law, the publisher can be dragged in as well as the writer. I mean, and sometimes the publisher is dragged in, obviously, because you finish up with people wanting a solvent defender rather than a man of straw. So that's one of the reasons. But it is, the publisher is seen as adopting. But that's the civil law.
Just on the issue of libel, if I retweet something, in the back of my mind, I'm always wondering, is this libelous? Now, when I retweet things,
Well, you know better than most, Simon.
but I don't necessarily agree with everything I retweet. I think it's interesting or provocative or thought-provoking, and so I'm not necessarily endorsing it. But if I think something is crossing that line, then I really do have to think twice, because
Didn't the Tory Party former chairman that was McAlpine, yeah, he I think took a charitable view to retweeters. I mean, it doesn't create any sort of precedent, but I think it's interesting. He kind of went for the main circulators of the message, and the retweeters. Did he ask them for a charitable contribution or something like that? So that one would imagine that he's properly advised on the civil law, and that potentially he could have sued those as well as the primary movers, if you like.
There's one area we've not touched upon, and these are offences which you could probably, if you can say it down the pub and it's an offence, it's almost certainly going to be an offence if you say it on Twitter or on Facebook. So I wonder, Ian, if you can perhaps help us how there may well be some aggravated offences, such as racially or even religiously.
Yes, they're caught by the relevant legislation, racially aggravated messages, etc. Messages that might constitute, what's the phrase the Act use? Also threats to kill, threatening to kill people, that is a specific and well-established offence under the Offences Against the Person Act, which is an 1861 statute. But stirring up racial hatred was the phrase I was looking for. So anything of that nature, where your intent is to do that, then you are really well over the threshold for a potential prosecution.
Just on the issue of retweeting, just crossed my mind then, which is that sometimes when somebody tweets something that's potentially libelous and they're threatened, as a community we often think, well, we're going to retweet that and it's going to have the Streisand effect, and we'll get it everywhere so that they'll know what they've let themselves in for. Now that can be really dangerous, because I think the phrase is poisoning the water. That the initial person that made that wrote the blog or made the tweet will have poisoned the water. And that's why we're all retweeting it. So if we do retweet things, we can be making it worse for the skeptic that's writing a critical blog. When my article was threatened with libel, Cosmos magazine in Australia wrote a very, very similar but bomb-proof article that said the same thing about chiropractors. And we very strongly urged people to retweet that, because we knew that there was no way they were poisoning the waters, because there was no libelous poison in the Cosmos article.
Okay. Doesn't look as though we've got the roving mic in here, so if we move on to questions, are people happy to stand up and shout them out? No dissent? Right, so we'll move on. This chap here.
Yeah, I'm wondering about social media, and with social media, and how do you determine where an offence has been committed? For example, if someone's sitting in a cafe in Berwick-upon-Tweed and tweeting something, it's picked up by a master of Scotland, where is the offence?
Yep. Where is the offence if you're on, I think, Berwick-on-Tweed, and it ends up being published elsewhere? I think it
Well,
is.
because it's picked up by Maston in
Yeah.
a different jurisdiction. This
Yeah.
Okay, I can explain the civil law, but I'm going to need a criminal person for the criminal part. Under Scots law, the delict takes place where the harm occurs. So if the person is in a cafe in Berwick and it turns up in Aberdeen, then the responsibility will be in Aberdeen. The relevant law will be the Scots law, because the harm, the delict, has occurred in Aberdeen. However, I'm not sure how the criminal law works. I'm sorry, I haven't done any crime since 2007.
I should put Ian on the spot. Complex jurisdictional question, Ian.
Yes, I haven't researched it, but there have been recently, I mean, generally speaking, the offence is where the criminal is situated, if I can call it that. However, there have been, that principle has been diluted with a number of statutes over the years. For example, sex tourism, etc., where we have prosecuted people for offences in Thailand and things like that. And I suspect if the message is readable in England and Wales, we would have a case in England and Wales, so it could be prosecuted here.
I mean, on the issue
I'm only 80% sure on that, but
Yeah.
one for me to look at.
Yeah, I mean, on the issue of libel, there's this phenomenon of libel tourism, whereby you sue the defendant in the territory that's most likely to give you victory, which often ends up being London and England. So it slightly worries me. I don't know what the Scottish situation is on reforming libel law in Scotland, because if it lags behind English libel law, then instead of people suing in London, they will end up then suing in Scotland. Also, Northern Ireland, I think the Scientologists are...
quite a nasty wrinkle there that I didn't mention in my earlier part, but Simon has brought it up and I should mention it. Whilst the Scots law is a bit more protective of freedom of speech, it is, it still puts the onus on the defender, which means he has to prove truth, veritas, and got a few more defences, but still puts the onus on the defender. But the statute of limitations in Scotland is different. In England, the claim has to be brought in a year. In Scotland, you've got 3 years. So if, for example, English law is brought into line with Scots law and speech is protected in England to the same degree as it is in Scotland, then you will, because of the difference in the statute of limitations, we will get libel tourism. They will come to the Court of Session in Edinburgh and make big claims. However, one good thing is that you can't have exemplary damages in a Scots court.
But it could be even worse than that, because again, for an online community and social media, is that every time somebody downloads one of your blogs, that counts as a fresh publication. So that 1 year statute of limitation starts all over again. So essentially, anybody can sue you anytime they want. And this goes back to 1852, and the Duke of Brunswick, who was living in France, in Paris, and he'd learned that the Strand magazine, I think in London, had written something defamatory about him 8 years earlier. So he sent his manservant to London, picked up a copy of the magazine from the publisher, which counted as a formal publication, which then enabled him to sue the magazine in London. Libel tourism as well, so in a way. So our internet law in England is currently based on that Duke of Brunswick case from the 19th century. Now that will change when the Defamation Bill is passed. There'll be a single publication rule, but I don't think that will necessarily exist in Scotland.
No, we would have to, Scotland would, Holyrood would have to enact legislation that applies in Scotland, because this is, the civil law is devolved, and it's not just devolved since the Scotland Act in 1998. I mean, one of the protections that was guaranteed to the Scots after the Acts of Union in 1707 was that the unique Scots law would be protected. So that's something that's very old and sort of built into the sort of structure of the United Kingdom at its core.
So there's a risk then that after the Defamation Act is passed, Edinburgh now becomes the capital of choice for libel tourism.
Or Belfast,
Yeah.
where the Scientologists like to sit.
Yeah. Let's chat it.
So I guess my worry is there are a lot of religions that find it very easy to say this comment or this tweet offended me. So what protection is there for those people, and to what degree would the panelists think that the law is an ass in that respect, and when's that going to change?
Well, your protection is Ian.
All right.
because it has to pass a prosecutor.
Yeah.
Um,
'Cause I mean, fair comment. You know, everybody here, I'm sure, has got views on religion, and just simply going online to. Well, I suppose it's different if you go and aggressively seek out people and make a comment, but if you're just sort of saying, I disagree with this, or I think this religion's wrong, or this guy doesn't exist, it's very easy for religious to say that offends me, and
yeah.
how's the law going to protect?
You could have a little rule that kind of says, well, what would Richard Dawkins say? And if he wouldn't say it, then maybe...
Yeah, moving on. No, it's a very good question, because we don't have a blasphemy law anymore, and to shoehorn new legislation to create what is in effect, or reintroduce a blasphemy law, I think would be a misuse.
But what's the current wording in the current...
Well, it would have to be grossly offensive. So I'm imagining, for example, well, I'll put Ian on the spot again. You've got a police officer who comes to you, Ian, and he says, I've just seen a chap in Manchester and he's uploaded a YouTube video of him burning a Bible. What would you do?
Unlikely to prosecute, I think.
Okay.
Yeah.
What if it was a Quran?
It's going to happen.
I knew that was coming, but still unavoidable.
Or a poppy.
Yeah.
Or a
Good point.
sorry,
Or a poppy.
Or a poppy.
Yeah.
Yeah. Grossly offensive. I mean, again, context would be.
Why would burning a Bible not be prosecutable, but burning a Quran would be?
Well, that's easy.
Well, it's because of the reaction that you'll get from that particular community.
Yeah.
Would that be a
I'm trying to think
consideration?
of examples. I mean, we had at the time when. Sorry, can you hear me at the back? I'm trying to remember the name of the villain that died. Notorious villain. Was it Harry Roberts who killed police officers? And we had people wearing T-shirts celebrating him when he died. Again, it's the offensiveness issue. I know it's not social media. We didn't prosecute in that case.
Well, there was a chap last year in Manchester, wasn't there, who was prosecuted for wearing a T-shirt in relation to the Dale Creedon case.
There was. I'm trying to remember the exact circumstances. That was, I think, within hours of the two officers being killed over in Tameside. So it was in a very particularly volatile place and situation and time, and all those issues came together at that time. I can't remember what he was prosecuted in the Public Order Act. I think.
He was,
yeah. So I think they illustrate that context and timing is crucial. I mean, I remember we prosecuted a woman for urinating on the wreaths at the Cenotaph in Blackpool.
Yes.
I had some involvement in that case at the time. In fact, one of a number of offences, so that perhaps isn't the best parallel to draw. So I think, it's difficult to give you hard and fast rules, but we'll apply a high threshold. We'll look at what's grossly offensive, in line with Lord Bingham's sort of guidance from the Collins case. Of course, before it ever reaches us, will a police officer investigate it? They've got a discretion, and if they don't investigate it, we can't set the ball rolling.
And there is one other little safeguard. Once the CPS have decided to prosecute, they sometimes send it out to council. A bit less now, but and council can have a look and say, I'm sorry, I don't agree, I don't think there's a realistic prospect of conviction here, drop the case. That does happen sometimes, so there's an extra safeguard there. More questions? Let's jump in.
What about the size of your following? Say, I'm on Twitter, I've got 8 followers, and I say something to them that I would say down the pub. One of them happens to be Simon. He retweets it to his 3 billion followers, and therefore it kind of escapes that little private world and goes out. How does that affect things?
I think the guidance does in fact envisage the size of somebody's followers on Twitter.
Yes.
And I think if somebody's only got 8 followers, then I would suspect any prosecution would be unlikely, even if somebody else then retweeted it. Because
it's also, I mean, just in libel, there will be a serious harm test, and there is also already a sort of serious harm test. And if you've got 8, say you say something about me, you've got 8 followers, that can't seriously harm my reputation. in theory, I could sue you for libel now, and that sort of thing does happen, and it's horrible. But the serious harm test will be very important. Now, if you are a member of the science communication community and you have 8 followers who are quite influential in that community, then you could seriously damage my reputation. So context, which has been mentioned already, is really important. And not necessarily the number of your followers, but who those followers are. And maybe how likely it is that you know that you'll be retweeted. If you know that you're followed by Guido Fawkes and that he may well retweet it, then again, it's really grey and difficult to pin down. But at the end of the day, the serious harm test is what should. And again, if I'm going to inhibit your free speech, I should only do that if the consequences of what you're saying are genuinely serious, which is why I think things like the Leslie Kemp transcriber libel case I mentioned earlier is bizarre. A Kawakatari-based company can be seriously harmed, or the owner can be seriously harmed by 2 tweets is baffling.
Andy. Can you shout?
Ian, could you possibly talk to why you think that anything that is that could be grossly offensive should be prosecuted?
Is it worth repeating that?
Yeah, I think the question was...
why should anything that's grossly offensive be prosecuted?
Yeah.
I think because the criminal law has always recognised that we have to protect individuals from harm, and harm has a wider context really than physical harm, and you can really seriously cause an enormous amount of alarm, harassment or distress, to use the popular threesome, to an individual if your activity, whether it's tweeting or whatever it is, if your activity is so concerted and so aggressive towards that individual.
So America is kind of the bastion of free speech, is my understanding. And when we've had libel law debates, we've always had a debate about how far do we want to move towards the American model. And then when I think about what happens in America, the Westboro Baptist Church protesting at the funeral of soldiers coming back from Iraq and Afghanistan, now people may find that grossly offensive. Now, they're not being prosecuted. Presumably, people do that in this country. That crosses the threshold.
Breach of the peace.
Okay.
Well, the Westboro Baptist Church would all be in jail. I have no doubt.
Yes.
And I suppose, and what Ian said, I think, is, as a society, I think people feel that would be the right thing. You know, I don't know what the split in this room would be like, but I think society out there would feel that would be that parents burying their son or daughter have the right not to be confronted with accusations on the day of the burial. So for most people, there is a line to be drawn. It's a case of where that line is drawn. In America, that line does not seem to exist almost. And as I said, that's why it's a free speech bastion. But I say, and the law is designed ultimately by politicians, and it's basically based on what the public to some extent wants.
Yeah. I mean, that's what we're trying to reflect, and that's why we're open for consultation. You know, give us your views. Whatever stance you take, if you think we shouldn't at all protect individuals, then we'll hear that and take it into account as we formulate our final guidance.
And ignore it.
Possibly.
Aisha.
I had a question then.
Thank you. I had a question then following on from the topic of picketing funerals, with obviously a funeral coming up very shortly. I'm just wondering if you had any perspectives on that.
It's going to be very busy.
I think, I mean, looking briefly at this morning's press, I think the worries really are around not so much internet activity, but what's going to happen on the processional route, that sort of thing, where we may get old-fashioned, if I can call it that, public order type situations developing.
Could you just give us an idea of those kinds of offences? What would people be committing if they, I don't know, protested the funeral in a criminal way?
Yeah, I mean, if it's the threat of or use of violence towards anyone, then we're looking at affray, Section 3 of the Public Order Act. Below that, there is using threatening, alarming, insulting words and behaviour, causing a disturbance, Section 4, Section 5 type offences. I don't think we're going to look at the top end, which would be sort of violent disorder or riot. I don't get the sense that there's anything as sort of organised or as...
so riot's not predicted?
Well, you can never tell.
you know, obviously the situation does arouse passions, and the individual concerned, you know, has you know, already done that. But
what can we get away with?
I would imagine we're going to get their seat now. I would imagine that if at all, it's going to be sort of a fray, and the Section 4, Section 5 offences under the Public Order Act that are most likely to be encountered.
So somebody had a placard saying, I don't know, "Ding dong, the witch is dead," something like that. Would an offence be committed?
Probably not. You know, offensive, shocking to some, but you know, again, come back to Bingham's judgment. I think we've got to have a margin of appreciation, as the European lawyers would say, and I would suspect unlikely to be a prosecution.
I think we've got time.
I was going to say, but I think we're talking about the law here. We're talking about criminal law, we're talking about civil law and libel and so on. And it's where the state intervenes, or where somebody else says, right, we're going to take to court. But there are also a different set of not laws, but you know, the people you work for may have an opinion about what appropriate conduct is, as we found out from the police officer who was sacked recently. The BBC isn't following the law when it makes its decision this evening in the top 40 list. It's following its own producer guidelines and so on.
It's taste, isn't it?
It's about taste and decency, which will depend on your academic institution or your workplace or your colleagues or your family and so on.
I don't have a Twitter account, and I will never have one, because the professional guidelines from both the Law Society of Scotland and the Faculty of Advocates, and because in due course I will be a solicitor advocate, is that it is not recommended for members of the profession, because you can just be too indiscreet. So you will never see me on Twitter. I mean, I've got a strong Facebook presence and I've got a blog. I know how to run those in such a way that are compatible with my professional duties to the court, to my clients, and to sort of the wider ideals of the rule of law. But I've got duty to the profession as well, and very often Twitter is incompatible with those.
I'd also like to see a lawyer who can say anything in 140 characters. That would be impressive.
You have seen my Twitter name, haven't you?
Oh, yeah, sorry.
Keep it brief.
Yeah.
And that is where we're going to have to leave it. Thank you very much.